Chebukati a request for donation of the 2 minutes to him, but I really would wish not to be so gratuitous.
Thank you. Madam Chief Justice, if you may allow me, I did not put one of our lawyers on record, Mr. Donald Kipkorir, who is not in court because of the sitting arrangements. But to come to the business before us, in answer to the questions, four of us will deal with all the questions that were asked by the court, beginning with my honourable friend, Mr. Paul Mwangi.
Madam Chief Justice, Madam Lady Deputy Chief Justice, my lords, my ladies, I have 9 questions which I'll tackle very first. What I have done is I have classified it into topics because they were across the board. The first is the relevance of rejected votes in the count of the election. This is a matter that we have asked the court both in 2013 and 2017 to relook. We wish to resubmit as we resubmitted the 2 times, and to say that it is still our position that people who come out to vote, whether their vote is counted or not, are coming out to make a stand on the issue, and whether either due to technicality or other reason their vote is not counted, they must be not treated as those who stayed at home. They are people who came to express an opinion on how they want to be led, but for various reasons their vote was not counted. But the fact that they appeared should be taken into account, so that you would consider their votes whether they are rejected, and even if they are called stray ballots, should also be considered in that sum. The second question was regarding the scientific whether there are any scientific studies regarding the nexus of elections in a postponement. We have seen, unfortunately, we could not tender any further documents of this, but there are very many theories in political science, one of which we came across with the contagion theory, that elections affect each other. People come out to vote for various reasons, and especially when you're dealing with elections of a national level and a devolved level, there are very many considerations that would make somebody want to come to make a decision on a devolved government or a national government and not necessarily care about the other. But one of the things that we also must consider in Kenya's political culture is that in Kenya we do have 6-piece kind of campaigns, and that people come out to campaign together as teams, trying to win across the board on all the seats. And that when you disenfranchise one, when you stop one election, that means you demobilize part of the political infrastructure that is laid out for that. And lastly, on this point, we want the court also to consider that, at least in respect of Mombasa, and our evidence has shown that there was an order from the Mombasa High Court that has stopped the printing of these ballots, and that was disobeyed. There was also a promise that had been made by the chairman that he will not print, and he went against that too. And lastly, that it was announced on the last minute in that night. The third issue was what elements of Section 80 of the Elections Act we consider necessary in the face of the fact that we are also impeached the process. Apart from the elements that are laid out themselves in Section 80, which is that upon a recount, the person should have been a winner, and that the person should be found not to have committed any electoral offense. In our submission, we wish to add that first, the test should be whether the petitioner is culpable for any of the wrongdoings that is complained of. Secondly, whether the petitioners are taken on a JPEG format, and the idea of the law of electronic transmission was that that image must appear as it is on the other end. The issue here is that there appears to be a place at which that format was changed. No reason has been given why that format was changed, so that it can go to any other format. But also to add that through one of the most popular applications today in Kenya is WhatsApp, in the affidavit of the second petitioner, Martha Karua. And in that flash disk, there are two incidences at the National Tallying Center. In one incident, Commissioner Justice Nyang'aya comes out to read the results of Kiambu Town constituency. After he reads the results, it turns out that the result he has read has overstated the votes of William Ruto by 10,000, and also that he has gone past 100% of the votes cast, and he is forced to have to come to reread the results. That shows the commissioner had not known what he was reading. The other video is that also of Juniera Cherere. Again, she is given results to read of Juja constituency with the same results, inflated votes for the respondent, and a more than 100% voter turnout. And again, the results have to be reread. That would leave it to the commissioners themselves to explain. The other issue is about the constitutionality of Regulation 87. Now, first, our position is that a regulation or any act that is unconstitutional does not need the order of the court to be nullified. It is already nullified by Article 2. And at any time, it remains a nullity ab initio. The second issue to consider is the duty of every person, not just the court, to defend the Constitution as required by Article 3. And the fact that this chairman, the chairman of the IEBC, is a person who has qualifications similar to be the Supreme Court judge. So it is him who has betrayed the Constitution. It is him who has seen a regulation which is so clearly unconstitutional, has refused to defend the Constitution, and instead feigned ignorance and purported to use an unconstitutional provision to exercise power. So on that basis, every action that is done on the basis of that regulation is itself unconstitutional. The other question was regarding why the four commissioners did not raise issues to the end. Again, that we will leave for the commissioners to decide, but we can profile three theories. One is the issue of the 89th minute penalty, that if you participate in a game and the wrong penalty is given on the 89th minute, you cannot be asked, why did you play all along? Sometimes it is the 89th minute penalty that shows the unfairness of the provision. It could be the last straw that broke the camel's back, or it could be a road to Damascus moment. In whichever fashion we look at it, it is an issue that is understandable. The other question is in regarding for if there were to be ordered an repeat election, who would conduct it? Would go back to Article 250, Sub-Article 10, because the Constitution provides for positions of vice chairpersons of all commissions. But Article 250 does not lay out any roles that they're supposed to be undertaken by those vice chairpersons. Our position is that that provision is not empty, and it is meant to provide for succession plans in commissions in places where an emergency or situations such as this, where such a succession is necessary. But the second issue would also be that the court itself, in inherent powers, has the power to ensure that its orders are fully obeyed and fully executed. And in such a situation, the court would treat its order as an order that has to be executed and would have the inherent powers to make all such other orders that are necessary to ensure that those orders are executed in full. Before I go to my last issue, I want to comment on something that was said about no agents. And one of the issues this court was told is that it appears there's a jurisprudence that is being built that where an agent does not appear from the other side, then the opposing side has a right to steal or a right to commit fraud, or somehow excuses the IEBC from any duties because there was no agent. And in fact, one of the advocates, like Kent, said that you must have agents in every place, and even likened to agents. I said they should be like your wife. I believe that is what was said. Apart from the fact that that statement is very sexist and insulting, not just to women, but even to constitutionalism, their courts must restate the duty of IEBC to protect the vote at all times in every place, and that it cannot pass the buck to parties when wrongs happen, and also must put the obligation on every contestant in an election that if you meet a place where there is no agent, it does not give you a right to steal the election in that place. The last issue, and I follow this up with what my learned friend Maha did, I want to show the court a Form 34A from a place called Gasharaigo Primary School, and it is in Moranga, in Kangema constituency, in a ward called Murogo, in stream 2 of 2. And this document is overlaid over some documents, but look at the left-hand top corner. It is overlaid over a document written Jose Camargo. Jose Camargo is one of the Venezuelans that was arrested at the airport with charges of coming to interfere with the elections. He is one of the people that the last Mahat has said did not have access to the RTS. This form is in the official portal of IEBC. The question would be, was this document photographed by a presiding officer at Gasharaigo Primary School, sometimes possibly at 8 o'clock in the night? Or is it possible that this document has been photographed elsewhere in some office and uploaded? This, we ask the court to read the DCI report regarding Jose Camargo, and we believe, my lords, that these are the fingerprints of one of the suspects of the theft of this election. That is all.
Good morning, my ladies and my lords. I will pick up from where my learned colleague and senior Mr. Paul Mwangi has just left off. The court had asked that we demonstrate with examples in real time how the Form 34A was interfered with or could be interfered with. And I will do so showing you or using the IEBC's forms itself, straight from the IEBC, from the IEBC portal. My lords and my ladies, I will walk you back through the form that we have just showed you. I see that the court has laptops, which means you're tech savvy, and you can access the IBC portal right now. This is going to be a live demonstration, as the court asked that we do. I'm asking that we go to the forms portal in the IBC. We are projecting it up so that it's not said, because we have been accused of cooking things, forging things. We've been called many names. This is the IBC's own document. We're asking that you open on your own devices, but even as we show, Murang'a County, Kangema, Muguru, and Gasharaigo, Primary School 02. This is live. My lords and my ladies, we have downloaded a Form 34A from the IBC portal. And I'd like the court to just scrutinize this form before we go to other details. From where I am, the stamp. The stamp. My lords and my ladies, is that the IEBC stamp? It's on the IBC portal, looking like it's been superimposed over another stamp. We have been asked to show how are the figures changed. Now, my lords and my ladies, if we look at the votes cast, the first figure on the form is for Raila Odinga, 55. It's followed by William Ruto, 260. It's followed by, I think that's Mwaure Waiga, 001. And the last is Wajakoya, 000. If we sum up the total votes, we get 316. The total votes cast according to this particular form is 321, different from what we have just seen. The rejected votes are 4, which means already by calculation there is a problem. But we'd like the court to look at the total number of registered voters. A close scrutiny of the form shows that the number was probably 455, and the 5 is actually similar to the figures written in the votes cast. But somebody or somehow that figure has been changed to make it look like 488. Did not even have access to maintain the server. This is on the 9th of August, and at the top left-hand corner there is the name of one of the Venezuelans, Jose Camargo. This is the person who decided the president-elect of the country. It is on the IEBC portal. It is live. How did that come there? This person is the one who was interfering with the forms. We are able to demonstrate, at least a crumb was left. By God's grace, we found something. We didn't make this up. We were told we forged these documents. Now, this is how, my lords, the staging was happening. This is how the changes were happening. This is on the 9th of August. We were told they were not there. I'm going to do, because of time,
with your permission, Your Ladyship.
I beg your pardon. In our petition,
You let her finish and then you tell us what it is. They're responding.
It relates to an objection to what she's doing, Your Ladyship.
No, let her finish.
my ladies, my lords, that name, Jose Camargo Gregorio, appears in our petition. And is also, that evidence is also found in the affidavit of the second petitioner, one of the people whom we complained about as having interfered in the election and who were told had no access. My lady, we're going to take you again on the same IBC Live portal to show how the staging was happened. And because of time, if we can go to Bungoma. We want to do it live, and we're doing it live on the IBC portal. My lady, we were told about the KIMS kit and how they work. The serialization of the numbers. We have been told that each of the 42,201 KIMS kits that were used in the election had their own unique KIMS kit ID and serial numbers. Bungoma County, Mount Elgon, Chesikaki, and Songoyo. We'll download the form. The nomenclature of the KIMS kit and the form is shown at the top on the address bar. And for purposes of time, my lady, what we're told, it will show you that that's a Form 34A. It will give you the serial code of the polling station from which that Form 34A relates. And then it will show you the KIMS kit serial number or ID. There'll be a date stamp and a time stamp. What I'd like the court to focus on is the serial number, and perhaps because I can't see from here, this is where I would have liked the court to have its own, but maybe if it can be. Do you have a roving mic? Now, The serial number on this particular form, my ladies and my lords, which I would have liked for the court to confirm for itself. If somebody there can, may I ask one of the court assistants to read for us the serial number as it is, so that then I'm not accused of making up things.
That's all right. It doesn't change anything. Evelyn, could you read that?
The number that starts with F2, it's in the middle. Or can I read it myself?
I can't see it. The one on top.
Yes.
PR06.
No.
Oh, sorry. F2.
My ladies and my lords, what would require is that you note down that number. We will compare it with another later.
It reads F2 3045 0M 00204 133.
The time, please. It's right next on the date.
That one. The time is
the date on which
9th August 2022 at 1956.
We'll check another form. Nyeri? Nyeri Town? Gatitu? Morogoro? Tunguma Primary School? Stream 3. Kindly read the serial number.
F230450 M00204133.
And the date and time, please.
9th August 2022 at 23:49.
My ladies and my lords, this is the same KIMS kit transmitting or sending results, one from Mount Elgon, 1,000 kilometers away from Nyeri town. 2 hours later, how is that possible? When each KIMS kit was supposed to have, each polling station had its own unique KIMS kit, which was supposed to transmit from this, its own unique IP address. Because of time, I cannot demonstrate the thousands of forms that we have identified with the same issue. My ladies and my lords, this is how the staging or the complaint that we raised happened. We did not give this court a fiction. What we gave the court happened. Now, staging, and as we have shown, the 11,000 polling stations that we had complained were staged were transmitted all from one IP address. Every KIMS kit was required to have its own unique IP address. The only way 11,000 KIMS kits or results can be transmitted from one IP address is if they were collected, and as probably my senior Paul Mwangi had. May I have, I beg your pardon, my time is up.
Yes, 2 minutes.
my ladies and my lords, the manner in which the election was stolen, the reason why staging was necessary was forms were intercepted like this. Whoever intercepted them then had time to decide which ones they could manipulate before uploading them and sending them to the IBC portal. The other reason that we know there was manipulation is because the original Form 34A is a colored form that should have appeared at the National Tallying Center if transmitted in one transaction as a colored form. All the forms that are on the IBC portal are in black and white. At what point were they altered from JPEG to PDF? When did that modification happen? And what other modification was done to the form? We submit to you that we have shown that not only was it possible, it did happen, and the fingerprints of those who interfered in the systems are still there. Thank you for your time. I don't know whether to be that generous. I donate the 29 seconds to the court. Thank you very much. At the insistence of my seniors.
May it please the court, my name is Kirago Kimani. My learned friend, Mr. Katua Kigen, had gotten the attention of the court, but was asked to wait until Ms. Soweto had completed her presentation. I would wish to respond to what she has just addressed you on, because this is new material, and would like to have direction.
Mr. Kirago.
Yes.
When I forget his name, Mahat was answering the questions, he did the same.
Yes.
He went through his PowerPoint.
That's correct.
To demonstrate.
That's correct.
How this staging was happening, because we asked that we be explained.
Yes.
How the forms were being captured in the hair. Yes. And being changed. And he did that.
Yes.
Going back to what he had done.
Yes.
So what is new here?
What is different is this. You have a petitioner and you have rules that say how they are to present their case.
This was answering a question from court.
Yes. Where does the first respondent have an opportunity to address these matters? At what point in time does the first respondent get a hearing?
This was a question by the court to demonstrate.
Yes.
How this was happening.
Yes.
What we do with the demonstration. Mr. Mahat, on your side, did demonstrate. And they have demonstrated.
I appreciate what your ladyship is saying, but Mr. Mahat, with respect, is not on our side. He is a referee. My client was a candidate. We are not on the same side. We may be respondents, but he called this match, not for us, but as required by the Constitution.
Mr.
But anyway,
Kirago,
the long and short of it, yes.
I'm
the long
sorry.
and short, yes.
We are not going to give you time.
Much obliged.
Yes, thank you. Proceed with, there were responses from the other petitioners. I'm beginning with number one, the same order we followed. You have responded. So who was next? It was, I think, Senior Counsel Jan Mohammed was her client. The same order we followed so that we don't waste time. If you can't use the 15 minutes, please.
Your Ladyship, Madam Deputy Chief Justice, My lady and my lords, I was very generous in my opening, so I'm sure I'm going to be just as generous and patriotic as I am in my rejoinder. I was the first one to donate 7 minutes in my opening.
Okay.
My lady, on behalf of the petitioner, in number 1, that's the second petitioner, we had filed a rejoinder of the submissions after our original submissions. And my lady, the petitioner's case is very simple. All it was the petition was limited to a legal issue. It was the role of the commissioners vis-a-vis the chairperson.
I saw people murmuring, and I want to get this correct.
I'm sorry.
Is it that we should then, because I thought you had a response, you had any question to answer?
In fact, my lady, the question I'm going to be answering is actually the rejoinder as to the role, as the answer to the role.
For purposes of orderliness, because we are trying to get our proceedings as orderly as possible, then we can start with the rejoinder by the first petitioner, then the others will answer the questions with their rejoinder.
Because my actually rejoinder is the response to the question of what the role of the other commissioners was vis-a-vis the chairman and the commission. Okay. That's what my entire petition is based on.
So then we start with the main petition,
that's
their
fine.
Rejoinder, then we come to you. I'm sorry about that.
That's no problem, my lady. I'll still donate my time.
Yes. Senior Counsel Olengo, it's your turn.
I'm just wondering, because if I heard the court correctly, there are some questions put to Mr. Mtata.
They will respond with their rejoinder.
With the rejoinder?
Yes.
Oh, okay, then that's correct. In our rejoinder, Madam Chief Justice and the members of the court will have 4 in our team giving the rejoinder. Senior Counsel Firoz Norji, Senior Counsel Otiende Amolo, and Senior Counsel Philip Murgor, and I'll have 5 minutes at the end. But I'll begin with Senior Counsel Otiende Amolo.
If it may please your ladyship, this honorable court, I will be brief in this part. I will cover only 3 quick subjects, starting with the issue of the 50% plus 1. Your ladyship, this honorable court, may it be noted that the question of the voter turnout in this election is a moving target. It is a moving target depending on who's speaking and in what circumstances. If you look at the replying affidavit of the chairman, paragraph 30, as of 9th of August at 5 p.m., he says the turnout was 64.6%. That is an affidavit he's swearing way after the fact. The director of elections of that same date, at that same time, in paragraph 21, that is Moses Nkuli, says it was 56.17 at that same time, looking at the same Kimskit. It will be noted by this honorable court that at various times, the IBC gives different figures. At one time, it uses the figure of 65.4%. At another time, it uses the figure of 64.6%. It is our submission, my lords, my lady, that the premise upon which IBC proceeds is wrong, and that the reason for this moving target is so as to manipulate the question of voter turnout, to come to a conclusion that the 9th respondent met the constitutional threshold when they didn't. I wish to submit, your ladyship, my lords, that Article 138 is very clear, and the total number of registered voters must be specified, and that is the denominator. The IBC did publish a gazette notice that confirms the exact number of registered voters and gives it as 22,120,458. In this court, using what they say is the turnout per the Kimskit, The figure they are seeking to use is 22,005,541. We wish to submit, Your Ladyship, my lords, that that premise is problematic. The common denominator to be used is the voter turnout as published in the Gazette, not the voter turnout as per the KIMS kit, which ends up with a moving target. We wish to submit, Your Ladyship, my lords, that not only is it true that the target is moving, if you look at all the permutations, and this is in the supplementary affidavit of Dr. Edgar Otumba, if you take any of the scenarios and you use any of them, and we will submit, we have submitted this for ease of reference, because Dr. Otumba covers is between paragraph 5 and paragraph 30, and puts all those graphs. By whichever permutation, none of the candidates then achieves 50% plus 1. Whether you use, remove rejected votes, you add rejected votes, whatever permutation, and there are 7. We wish to submit, Your Ladyship, my lords, that you then need to come to the conclusion that even though they try to take time to tamper with the voter turnout, they do not achieve that target. The last point on that. Why is it wrong to use the vote turnout as per the so-called KIMS kit? Other than the fact that it's unlawful, it is also illogical. We have 46,229 polling stations. If you are to rely on the KIMS kit, and all 42,298 KIMS kits failed, and only one in one polling station functioned, then it means that if the 700 voters in that polling station voted, the IBC will be telling us that the voter turnout is 100%. That would be the logical consequence of that narration. That cannot be. The voter turnout cannot be something that depends on the interpretation of the IBC at its convenience. It must be the denominator as a percentage of the total registered voters. My second point, my lords, my lady, and I do not want to go too much into this, the question of the infrastructure, what the IBC called the impregnable military style infrastructure. I think it's been demonstrated that it was certainly not at a military grade. It might be important to note, Your Ladyship, my lady, that the one question they failed to answer was why was there stoppage of the streaming of the results at Bomas? They have not answered that, because that military grade infrastructure was obviously compromised. My lord, my lady, we say that it is bad to have a sovereign institution that is captured by the state, but it is worse to have one that is captured by foreigners. We submit that is the position in this one. Your Ladyship, my lord, the question here, and that's my third and last point, is really very simple. And it's a question that draws directly from Article 138(3)(c) of the Constitution. It is very clear, it is mandatory, that once results are received, the IEBC, not the chair, shall tally and shall verify, then shall declare results. If the IEBC as an institution has not tallied, has not verified, then there are no results to be declared. We wish to submit that at the end of this analysis, it is not a question of whether the chair is a hero or otherwise. It is a question of whether the chair did what was expected of them. It is not enough to say that there are certain regulations by the first respondent which they themselves made and now they wish to rely on to breach the express provisions of the Constitution. We wish to submit, Your Ladyship, that in accordance with Article 141, only if there's a result properly declared can you even move to challenge it. In this case, none was done. Your Ladyship, what the chair is inviting you to do is unconstitutional, This bench comprises eminent persons who are involved in the process of making the Constitution, as some of us on this other side. There's a good reason why we've created constitutional commissions and independent offices. If it was intended to create the chair as what was previously called the supervisor of election, there'd have been an independent office, like the Auditor General, Controller of Budget, like the DPP. But now the chair is inviting you to find that his is some sort of imperial chairmanship or chairpersonship in defiance of the Constitution. We wish to invite you not to accept that invitation to amend the Constitution belatedly. My lady, my lords, at the end of the day, the only question will be, did the chair act in accordance with the Constitution? Is it fair to invite you to find that the other commissioners do not matter? The chair of IBC is a first among equals, just like in this court. There are 7, just like the judges of this court. But the fact, your ladyship, you are the Chief Justice and you are the President of this court. Yet the Constitution would not allow you to exercise veto powers over the other colleagues. Why would the chair believe that he can have such powers over the other colleagues? Ultimately, my lords, your lady, it is the decision of the majority that must be the decision of the court. And similarly to the IEBC, as we are here today, the decision of the IEBC is that the match that was being played was stopped by the referee. If it was in court, it would be a mistrial. By their own admission, they have said that things happened which should not have happened, and therefore it was not complete. My lords, my lady, in 2017, this court made history by nullifying the first presidential election in this continent, and I think only the second known to me in the world. In this year, it is the IBC that is making history. It is the first electoral body to concede that they did wrong. I want to submit, my ladies, my lords, that you cannot override that decision. I wish to stop there for now. Thank you, my lord.
My Lady Chief Justice, members of the court, I address the court firstly on the issue that in making your final decisions, in reviewing your own views, the views of the respondents, petitioners, parties who have addressed you, we would be praying for the prayers and orders that we have sought. And in doing this, may I first refer to the principle that would be applicable in approaching your decision and judgment. In this context, the court has heard today from my senior AG Emeritus, Honorable Gitu Muigai, in answer to your question, that it was the intention of the makers, it was the intention of the makers that the commission should have an executive chairperson. That we have learnt much by that, but that is not what we or they and your ladyships and lordships can proceed on. We have to proceed on what is in the Constitution. There is no provision in the Constitution for the, even if that were the intention, there is no intention shown to override any of the other commissioners or their views or their actions, or to change the Constitution's clear provisions of Article 138(3)(c). The tallying has to be done by the IEBC. The verification has to be done by the IEBC. The declaration decision has to be made by the IEBC. And where there is a specific step to be taken in an executive fashion by the chairman, it's provided by 138(10). The declaration of the decision of the result will be made by the chairperson. Secondly, it is an important consideration. When yesterday the question arose of the two aspects. One, that although there was a further day still in hand, the chairperson rushed to judgment without the 27 constituency results because of the doctrine of necessity, said Counsel Professor Kindiki, in justification of this. The doctrine of necessity was not necessary at all. There was no crisis at that moment. They were, he has indicated, in great danger of their lives. But 20 minutes later, they were shaking hands with his client, and his client was shaking hands with a very able-bodied chairperson. Nobody left that hall in the imminent expectation of watching carnage and bodies lying all over the floor. No one. There were church people, 2 rows of church people. There were, and I am grateful to them, the choirs who had kept us not entertained only, but inspired through those hours and hours. There was no imminent danger. This continuous, they could not resist the temptation of showing a still photograph in order to show that there was a necessity. No, there was not. And it is very important to realize that we do not use these exaggerated criteria in order to come to a justification of plain wrong. Is it, the issue is, was the Constitution being followed or not? And that is where the concentration has been lacking from the respondents. An important aspect of this, of bringing forward the doctrine of necessity, is that it is a very dangerous legal justification. It shows the need to bypass the constitutional justifications and arrive at a subjective, convenient, and self-serving justification. And it is dangerous because it has been used before by lawyers as eminent as Professor Kindiki. It has been used in Rhodesia after the UDI, Unilateral Declaration of Independence, to hang freedom fighters who were resisting the Universal Declaration of Independence. And the doctrine of necessity goes one step forward to say that if power has been usurped, taken, otherwise than in compliance with the Constitution, the courts should still recognize the usurpation of power. And they were hung, not only in Rhodesia, but in Pakistan. After a coup, their courts accepted that the doctrine of necessity, the acknowledgement of what was shown to be the new Grundnorm, would have to be acknowledged. And so the coup was all right. And so my learned friend, the professor, is saying, you too must acknowledge. And what does the doctrine of necessity always acknowledge? It acknowledges wrongful taking of power. And the Grundnorm is thereby changed, and therefore the court must accept it. So they're basically saying to you, recognize there was need, recognize that the chairperson did this out of necessity, and therefore it has to be accepted. It was done in Nazi Germany. That's where the Grundnorm comes from. And therefore, we submit not only that you should reject it, but you should condemn the attempted use of it so that it can be used here now in this innocuous, apparently innocuous moment in a case in a hall full of lawyers and judges. But it is a very dangerous thing, not only historically, but because Professor Kindiki revealed, perhaps unknowingly, that we now know that the doctrine of necessity has been discussed in their private thinking and now is brought here publicly. And when there is, next time, there doesn't have to be a chair and 3 people and 2 policemen clearing the chaos. Next time, when there is a manufactured group assaulting another group of 50, 100, 200 people, who will get up and say, we have taken power as an act of necessity? Because our attempt to do so at Bomas to establish a new government not in compliance with the Constitution failed, as it should fail. But now, with the doctrine of necessity, we are there. And we will take on anybody who says that we are doing anything wrong, because the doctrine of necessity requires that we restore peace and order and move on And then when we bring the matter to court, learned Professor Kindiki will be here to say, I will now refer to the case of Mandus Butiro, South Rhodesian law reports, and say, here it is. Here is Pakistan. Here is the case from Uganda after the Uganda coup, applying the same thing. And we say, this is the prophecy that is put forward now in their thinking, shown unwittingly, I think, by Professor Kindiki, and placed before the people of Kenya. We say, not only reject it, but reject it consciously, so that the precedent is not of a submission which failed, but a precedent of the Supreme Court of our land rejecting this ever for use in Kenya. So what should we be using? I'm happy to say that again from the respondent's side, I draw some inspiration. And that is from my learned friend, Senior Counsel Fred Gatia. My learned friend, both learned and friend, put forward before the court, and he said, let us get at the substantive truth. He put forward a criteria completely different from Professor Kindiki. And I'm happy to say, yes, let's do that. So we put to you, when we put forward the manipulated postponement of Mombasa and Kakamega, we showed to the court that the Gazette notice, the power which Mr. Chebukati used was illegal because in the Gazette notice, he lied and put forward just half of what the power he has needs to meet. And so, when we put these forward, they could not reply, but those who attempted the reply said, but look at this. This is his power, this is his this is his section here, and he's an executive, he's this. But Senior Counsel Gatia's principle was a more important and relevant approach. So we say, what is the substantive truth behind the postponement, behind the lying Gazette notice, before the self-serving amendment of the Regulation 67 by which he changed, this chairperson changed, or got changed, the constitutional provision that the papers 34A and B received at Bomas must be dealt with by the IBC Commission. Instead, he changed it to the returning officer. It has been pointed out there is no such office, and he put it there. What is the substantive truth behind this? What is the substantive truth behind the fact that despite several orders from you, the server has not been fully opened? What is the substantive truth behind the fact that this is not the first time this chairperson has disobeyed the court? What is the substantive truth of the absence from his behavior of any reference to Article 10? Article 10 is values. They are national values. And the beauty of our Constitution is that it is not only a manual of government, finance will be dealt with this way, so-and-so will be appointed that way, he can resign or he has to be removed or this or that. Each and every chapter has its specific values set out therein. 81, 86, and at no point in the whole of the day spent and today, this morning, has there been any reference by the respondents' council or supporters, or by any reference to instructions, that these values we kept in mind. This is how we advance. By postponing Kakamega, this is the value we advanced. By not checking the wrong printing of the ballot paper, how did we advance Article 10? There is even one more duty on them, on the chairperson. It is that it is part of the duty of the chairperson, the whole commission, to ensure the removal of any impediments to the functioning and the purpose and the aims of the commission. They have breached even that, even the passive duty. And we say, yes, that is what we look at, the substantive truth of all these things. And in that, once you do this, it is clear that this is an election which is brazenly, shamefacedly, without remorse, saying we did right when we were doing wrong. You do what you can about it. Nothing happened to me in 2017 personally. And it is all right. We say no, and we say to the court that not only is the petition, we pray, to succeed, but very importantly, if you find that there is violation of the Constitution by the chairperson, it is not necessary for the court to take any steps to his removal. There is a constitutional position. Thank you. There is a constitutional process to remove him, and there is no need for the court. But there is an important duty on the court that if you find a serious violation, and we submit there are all these serious violations, it is important that the court makes a finding. We hold that, or we find that the chairperson violated this article or that value, and that those are set out. We pray accordingly. Thank you.
Having just come in, good morning, Your Ladyships and my lords. I'll take as short as possible. In order not to repeat, I will be very brief. Arising from the questions asked by the court, I'd just like to put it on record and of course, in particular, the very rapid submissions of my learned colleague, Mr. Mahat. Sometimes you miss exactly what he's saying, but I picked out that he did not at all mention how the system for the KIMS kit was converted to the provision of PDF. The tender document, and we have provided evidence of it, did provide that the KIMS kit would transmit a compressed color photograph image using a compression technique that is in compliance with JPEG. That requirement was never changed unless it was changed quietly, fraudulently, and with the sole intention of rigging the just concluded presidential election. My learned friend, again, Mr. Mahat, challenged everybody that if there was a program that could convert a PDF document or could edit a PDF document, they would buy it. They would buy it. I suppose he meant the IEBC. I, at that point, did ask whether he's an employee of the IEBC, but I was assured he was not. I would like to state for the record that the software for editing a PDF document is available free of charge and can be downloaded by him or the IEBC. And we would request that millions of public money not be used to do this. But the programs that exist for editing a PDF document include Adobe Acrobat DC, Foxit PDF Editor, PDF Filler by AirSlate, PDF Element, Small PDF, Nitro PDF Productivity, Fine Reader PDF for Windows and Mac, Adobe PDF Pack. And I would also invite the court perhaps to try any one of them out. Staging, I just want to add that staging is admitted even by IEBC. So it does not lie in the mouth of counsel, belatedly briefed, to deny that there was such a facility. Mr. Maina Washira Nyaga, paragraph 2 of his affidavit, sworn and filed on 29th August 2022, confirms there was a middleware in the results transmission system. And this is also confirmed by one of our IT experts, Mr. Benson Wesonga, that there was indeed an attack from the position of man in the middle. At page the evidence we produced of the data analysis by George Njoroge in his affidavit sworn on 28th August 2022 and filed on the same day, pages 68-73 of his report, Mr. Njoroge says that the results from the results from the polling station was between the 9th and 14th of August tallied 137,000 times 137,847 times. On the 9th of August, 38,353. On the 10th, 35,000 times 574. 11th, 16,291. 12th, 8,357. 13th August, 14,357. 4th August, 24,000 times 897. This shows that numbers, the same numbers, were being brought back into the system from 34s, new 34s. Otherwise, and trying to find the magic number that would give the first respondent the win. Finally, I would like to make a few comments on the just concluded exercise the scrutiny exercise and state that very shortly that despite the good intentions of the court, the servers were not opened. Unless, of course, there will be another opportunity for us to make a few comments. They will? Or then?
Stop any conversation about the report at this stage.
Okay.
We will allow you time to deal with the report.
Okay. I want to say that the evidence that has been presented by the petitioners shows a well-orchestrated and fraudulent scheme that was executed with military precision. Let me agree with my learned friend, Mr. Mahat, on the use of the word military. He says military grade, but I differ with him to say the rigging was executed with military precision, and given the evidence that has been availed, using expert, foreign, and I'm now using another military word, mercenaries engaged for that purpose. I am not surprised that none of those gentlemen I'm referring to as mercenaries have not sworn an affidavit. People like that disappear and leave the country to its own devices. By the grace of God, we have remained peaceful, and I pray that we continue to do so. And finally, I will yield the floor to my learned senior, Mr. James.
Milady, Madam Chief Justice, we would like a clarification from the court whether the replies and responses relate to questions of law that have arisen from our presentation, or whether it is an opportunity for our learned colleagues to rehash their case afresh and to introduce new evidence.
We know what constitutes a rejoinder. It's a response to issues of law arising from the respondent's response. So just to remind Council, it was about responding to matters of law.
Madam Chief Justice, I also rise to take or to request a clarification. The court was treated to a so-called live demonstration. Shall we be given an opportunity, we don't require more than 3 or 4 minutes, to indicate that what the court was shown is not true? Because otherwise, this image is now all over the country, a sensational image about forms with the names of people, whereas in truth, that is not correct. All that I would request, Madam Chief Justice, is an opportunity for rebuttal. On the basis that that is new evidence, it was never played, those are not polling stations in the petition, it's totally new. It will be unfair for us to walk away without being given an opportunity to defend ourselves.
Unless the court walks away from the questions that the court asked, you asked for a demonstration of how the staging was done. It was a specific question. And similar questions were asked to our friends to the left. A lot of new material was brought in. We kept quiet, because we knew these were questions from the court and that no evidence should be kept away from the court in the search for truth.
What we are doing, and then at the end of it, we'll consider, because we are also checking whether that is new evidence. Yes.
I thank you. I begin by thanking the court for giving me this opportunity to make my remarks as part of the rejoinder for the petitioner. My lords, when I used to be at Alliance High School, every year, Professor Giddu is very happy about me mentioning his school. When I used to be at Alliance High School, every year I took part in a school play. Most of the time they were Shakespearean plays. Macbeth, Julius Caesar, Much Ado About Nothing. Can I recover my 4 seconds? Yes, I was saying I acted in every school play for 6 years. And when I became a practitioner of law, I tended to have the habit, every time I would appear in court, to take some verse from those Shakespearean plays, be it a comedy or a tragedy. And one time, S.M. Otieno, from whom I learned a lot as a young man in the practice of criminal law, he told me when I took my seat, did you read the charge? Did you look at the statements? Did you analyze the elements or the ingredients of the offense? Always remember, as a lawyer, that oration is not good enough. Substance counts when you appear before the court of law. And I'm saying this because in 2017, when he had a similar petition before your